According to news reports, Siebert had recently expressed concerns to DOJ officials about the viability of going after Comey. Eric, pathetic. Were you just incompetent, or were you partisan and biased and you didn't want to go investigate these criminal defendants, which is your job? Based on that one statute, they're going to divest the executive branch of all of its appointment powers. You get 120 days, use it or lose it, bucko. Or else. Letitia James and James Comey, both popping champagne bottles today. Their cases have been dismissed, but that might be a bit premature. Still a long road ahead for both of them. We've got these orders that came down from a Clinton-appointed judge in both of these cases, the James Comey case, and you can see this one looks almost identical, the Letitia James case, both coming out of the Eastern District of Virginia, and they're both orders granting the motions to dismiss. Now, it's a very technical explanation by this judge for why Lindsay Halligan is not allowed to bring these prosecutions, but it's so narrow that this leaves us with a couple of options. First of all, we can appeal this and see what the Fourth Circuit says, whether they would say, actually, this judge's interpretation of the law is wrong and bring these indictments right back. Or, as I think we'll see as we go through this and hopefully can tease out with the judge's language, there's another option as well. If we do not want to appeal Lindsay Halligan's role, maybe we just assign another special attorney to come in and take the case over and prosecute them anyways. And we've got a 6-month window in which we can do that. We'll break it all down. So here's what the judge writes. All right. On September 25th, Lindsay Halligan, a former White House aide with no prior prosecutorial experience. So what? That's just opinionated, slanderous type of attacks from this judge. She appeared before a federal grand jury, and having been appointed, these words are key, interim U.S. attorney just days before, she came and got a 2-count indictment in front of Comey for making false statements and obstructing a congressional proceeding for being a liar. We've looked at his emails. This dude is as dirty as it gets, and now he's going to be celebrating the escape of this fleeting prosecution. Now, Mr. Comey now moves to dismiss the indictment. He says Lindsay, the sole prosecutor who presented to the case, was unlawfully appointed in violation of 28 U.S. Code Section 546. Okay, so these numbers, we're going to do our best to keep track of them, but 546 is the appointment power for Halligan. 546. She says, okay, as I agree, I'm going to explain below, the judge says, I think that that was invalid, and it's all going to hang on an interpretation of this statute, right? Which I think she's wrong on, as we'll look at. And because Ms. Halligan had no lawful authority to present the indictment, I'm going to grant Comey's motion to dismiss. Letitia's also got dumped on the same basis, but you'll notice here, it says without prejudice, which means they can come back again and file it again. Not done. This case is just done, but you can bring it back. Now, we know, and we're going to come back to this a lot because the appointments clause, it is part of the executive branch. The text of the clause says that there's 2 types of officers. Article 2, okay, that's the executive. It says you can appoint people, inferior and officers, and there's all these rules about it. Now, for the United States attorneys, Congress has preserved the default rule. Okay, for U.S. attorneys, we know, we've been through many of them. President appoints them, the Senate confirms them. That gives us a lawful U.S. attorney, giving us the rules there. And then we have the code, okay, 28 U.S. code. So the Constitution, then Congress comes in, they explain what the Constitution means and it enables. They pass this statute, Section 546, which is what Lindsay Halligan used. And the judge is going to scream about this and say you used it inappropriately. Section 546, judge writes, essentially divides the responsibility for making interim appointments between the AG and the district courts. So if you don't have an official U.S. attorney, like in other words, Lindsay Halligan, as we remember, she has been appointed, but she has not been Senate confirmed. So that equation has not been satisfied yet. So what happens in a situation where we don't have that completed? The law, Section 546, which Halligan relied on, it explains. Now, the AG may appoint a U.S. attorney for the district in which the office is vacant. Okay, pretty simple. Vacant U.S. attorney, office, Cam Bonney can make the appointment. Now, if the Senate refused to allow that person through, you can't put that person in there, right? A person appointed under the section may serve until the earlier of one of these two. One, some other U.S. attorney comes in. So you have this person sitting in the seat until an official confirmed person can come and take the seat, or 120 days expires, right? So we're several cycles into the president right now. We're in November. So we've had several 120-day periods come through, and they explain you get 120 days. You can sit there for 120 days. Now, if an appointment expires under this section, so we're in this section C2 right now with Lindsay Halligan, and she had a prior U.S. attorney in there before who expired. If 120 days expire, this says, comma, the district court for such a district may appoint a U.S. attorney to serve until the vacancy is filled. You see that right there? That may word, pretty important word. The order of appointment by the court shall be filed with the clerk of the court. So if the seat is empty, the court may appoint appoint a U.S. attorney. In other words, we appoint somebody. We should have replaced the person who's in Lindsay Halligan's seat. The DOJ doesn't have the ability to fill that seat. And again, it's may. And we've gone through this a bunch, right? If it's shall, then it's mandatory. It's you have this responsibility, court. But may, in our interpretation, is discretionary. You can do it or not. If the seat is empty and the DOJ, for example, the executive branch is not filling it, then the district court may go find somebody and fill the seat. We don't want empty seats. So if the DOJ is dropping the ball and they don't have somebody in the seat prosecuting these cases, the district court can go and do that. But it's not only the district court can do this, or the district court shall do this, or this is exclusionary to the executive branch at all. Remember that the appointment power is back in Article 2. That's the executive power. So why would we just shift that away? In other words, you get one option at appointing somebody, otherwise you lose it after your 120 days. Then the court just gets the appointment power under Article 2. That makes no sense at all. On January 20th, Jessica Aber, who had been nominated by Joe Biden and confirmed by the Senate, she got out of there. She resigned. Good riddance to Jessica. The following day, the Attorney General then appointed Eric Siebert. Pam Bondi comes in January 21. Jessica's out. Eric comes in, appoints him under Section 546, the section that we just read. He was there for 120 days, and it was set to expire on May 21st. So on May 9th, the judges of the district exercised their authority, and they appointed Siebert to continue the role. That was effective May 21. So they came in, they said, you're back up. Eric, you're about to expire. We like you. We're going to keep you here. Then on September 19th, Siebert informed colleagues he was resigning. He's out. According to news reports, Siebert had recently expressed concerns to DOJ officials about the viability of going after Comey. Eric, pathetic. And Tish. He's like, I can't find any evidence. I don't know where the evidence is. We've seen it in Comey's emails. Eric, did you not read the emails that were in the file? Did you even look at it? Because we've seen it. We've seen it all. Lindsay Halligan dumped a bunch of them on the docket for all of us to read. So Eric, were you just incompetent, or were you partisan and biased and you didn't want to go investigate these criminal defendants, which is your job? Anyway, Siebert, his resignation came hours after Trump told reporters that he wanted Siebert out, which is a good call. Should have happened a long time ago. Pam Bondi should have identified this person and gotten rid of them a long time ago, not waiting until, if anybody's going to be criticized here, it's this. Why are we waiting until September 19th to make this happen? Comey's statute of limitations expires on September 30th. Waiting till the last minute. Then Lindsay Halligan comes in. Then Trump posted this. He says, Pam, the hell is going on over there? He says, will you do your job now? Justice must be served now. President Trump, go do it. Less than 48 hours after Trump made a good post about this and Pam woke up probably in cold sweats and then went back to bed without indicting anybody, the Attorney General issued an order. And the order appointing Lindsay came in and said Lindsay Halligan is going to be the interim U.S. attorney. And again, under this provision, 546, which is just what we talked about, the 120-day interim attorney rule. Now, Eric Siebert has already been in there. So he says, I can't find any evidence of this. This feels egregious. He leaves. Halligan comes in and says, are you stupid? Look at all this evidence. Indicts him. On September 25th, a grand jury, 5 days before his statute of limitations expires, if I'm not mistaken, on the September 30th date, a grand jury sitting in the Eastern District of Virginia comes back in. They're like, oh yeah, he's guilty. Eric, moron. They come back, 2-count indictment. They charge him with making false statements and obstructing Congress, which is like the bare minimum of what James Comey has done. By the way, these are not the actual crimes that Comey committed. These are Comey lying to Congress about the crimes that he committed. That's how far removed we are from any actual justice. We're like flailing around over lies that this guy said, not even the actual crimes. And the case just got dismissed. All right. But the charges stem from testimony that he gave in 2020. 5 years coming and going. Halligan was the only prosecutor who participated and only her signature appeared on the indictment. So the judge says, all right. On October 20th, Mr. Comey moved to dismiss the indictment on the grounds that her appointment was unlawful, Section 546. On October 21, the chief judge of the Fourth Circuit designated me, so the Obama judge goes and finds a Clinton senior citizen judge, to consider this and any other motion about the disqualification about Lindsay Halligan. And continuing, says, finding it necessary to determine the extent of the grand jury proceedings, I asked for all of the information from the transcripts. I got them all. Upon reviewing the transcripts, I determined it did not include any remarks made by Halligan before and after the testimony of the sole witness. So I directed the government to give us more info. Then they submitted a notice. They said, we've already given you everything, Judge. The government provided the transcript. The court's subsequent demand asked for more. We contacted the transcription service and they transcribed everything. So you already got everything. Quit your crying. On November 3rd, the government responded in opposition to the motion. Also, they submitted another order. Okay, so Pam Bondi came in. She issued an October 31st order. But remember, statute of limitations, already expired. But put a pause on this because we're going to have a remedy that I think will be coming soon. The October 31 order reads in part the following. So now we know Halligan has been appointed. She appointed her as interim under Section 546. Pam Bondi says, on September 22nd, I exercised authority vested by the Attorney General's office. Under U.S. Code, I designated Halligan as the attorney, interim attorney over there. For the avoidance of doubt as to the validity of that appointment, and by virtue of the authority as the Attorney General, including these other provisions, 509, 510, and 515, I also appoint Lindsay to be a special attorney. Okay, so it's a separate, we can use this as a term of art, special attorney, using different provisions. In this case, really Section 515. And thereby ratify her employment as an attorney of the DOJ from that date going forward. Now, as special attorney, she can do a bunch of things, because if you go to Section 515, it says you can do all this stuff. Civil, criminal, grand jury proceedings, all these other things. And now she's also that. So I hired her for this role, and now she's also this role. So I delegate also authority to prosecute James Comey via Pam Bondi. So she's trying to kind of, backdate her appointment. Now, in addition, based on my review, I also exercise authority here to ratify Halligan's actions after the fact. Now, Comey responded after Pam Bondi submitted that. On November 13th, judge says, I heard oral arguments from the parties. I took the matter under advisement. And during the hearing, I asked about Halligan and her presentation to the grand jury and said, I'm still missing materials. I also note that based on my review, there's a gap in the grand jury transcript from 428 to 647 when the indictment was returned to the judge, saying, I feel like I'm missing things. Now, the day after the hearing on November 14th, the government filed an unsworn declaration from Halligan and a new order from Pam Bondi. Halligan said the grand jury transcript accurately reflects everything that was said. There's no additional materials to give to you, judge. You've got everything. That's the end of it. Now, the judge comes down and she writes, resolving Mr. Comey's motion, I need to decide whether Halligan was appropriately appointed under Section 546. This is the 120-day statute. If the answer is yes, I don't need to go any further. If she's valid, then Comey must be denied. But if the answer is no, and Lindsay is not valid, then there was no ability to present the indictment. And if you can't present the indictment, what is the appropriate remedy? Should it be dismissed or should it be ratified pursuant to Pam Bondi? I address these issues and start with Section 546, the 120-day provision. Now, according to the government, this case is simple. We read the statute moments ago. In its view, there's only one way to read this. Nothing in the text, it says, explicitly or implicitly precludes the AG from making multiple appointments. In other words, 120 days comes and goes. Okay, appoint him again or appoint different people. In this case, they appointed Eric Siebert. Okay, he's gone. You get another 120-day appointment. Do you know why? Because the executive branch has the appointment power. And the statute says may, not that there's a divestment of that jurisdiction and that authority from the executive to the judiciary. It just says may. If it is empty, then you can fill it. So this concludes that the Senate has not refused to advise and consent against Halligan, and so she's lawfully appointed. Now, Comey says no. You only get one 120-day period, and now they've already used that. She says, I agree with Comey. The preeminent canon of interpretation is to presume the legislature means what it says. Now, she says this is ambiguous, this section, which we just read it. It's not. Section A authorizes the Attorney General to appoint an attorney. Got it. But there are time limits on appointments made by the AG. It says 120 days. And this gives us one option. And here's what she says. If an appointment expires under C2, the district court for such a district, and only the district court, may appoint a U.S. attorney to serve until the vacancy is filled. As an or. It's as an either or. It's not saying that you suddenly take over all Article 2 powers to make appointments because 120 days expires. And we've had prior instances of successive 120-day appointments. We already saw this in the response to James Comey in the underlying argument in the briefing. The text and the structure of subsection D make this clear. The appointment power shifts. The DOJ has 120 days and then they're done. It does not go back to the AG unless you get a Senate-confirmed U.S. attorney. The first word in the subsection, if, introduces a conditional clause that establishes the condition triggering the district court's authority. Thus, if here it's may, they say the district court retains the authority, and so it's not yours. Now, this reading is reinforced by other documents in Johnson and White, 11th Circuit case, and other things. If the government's read is adopted, then it would mean that it renders insignificant the court's powers under the statute. It also conflicts with statutory history. Lots of case analysis here and going back through some of the history here. But the government says, no, Congress came back and actually ratified the long-standing use of 120-day successive appointments. They've done this before. Congress made some changes and reverted it back, so we can do 120 days. The judge explains the text, the structure, and the history are pointing pointing one direction. The Attorney General, Pam Bondi, the executive branch, you get a total of 120 days. That's it. If the position remains vacant at the end of 120 days, the exclusive authority to make those shifts to the district court, where it remains until you get a president's nominee confirmed by the Senate. I just can't imagine the courts allow that to stand. Based on that one statute, they're going to divest the executive branch of all of its appointment powers. You get 120 days, use it or lose it, bucko. Or else, Halligan was not appointed in a manner consistent with this framework. The clock already expired on May 21, and so since it expired, Halligan is gone. So I conclude that the attempt to install Halligan was invalid and that she's been unlawfully serving in that role. And now I am the president. I am the executive branch. The court gets to make the appointments now moving forward. Now, she says it violated the appointments clause, which is hilarious because the court is now saying we run the appointments clause. It's our Article 2 now, not yours. They say the appointments clause allows Congress by law to vest appointment in inferior officers. In the president, right? Constitution, Article 2, Section 2, Clause 2. What does this say? She wrote it right here. The appointment of inferior officers and officers are vested in, what does that say right there? Oh yeah, the president alone. Not some committee of judges somewhere. They get to say, actually, we don't like Lindsay, so we're going to appoint somebody else. The Constitution says the president alone. And the court in this decision is operating against that, which is why I think this will be reversed. Through Section 546, Congress has devised a scheme that vests this in Congress. And because Halligan was appointed in violation of this scheme, everything that comes from her is bad. Resisting this conclusion, the government says, well, not every action in excess is a violation of the Constitution. Lots of quotes there. But what is the remedy? Dismissal. Says this is more than just a matter of etiquette or protocol. Here, Comey says Halligan was unlawfully appointed, and therefore all of this was void ab initio. And I agree. So everything is invalid. He therefore argues the case must be dismissed because Halligan was not lawfully exercising executive power when she appeared before the grand jury alone. She agrees, the judge says. And so now the case needs to be dismissed. Now, I conclude that all actions flowing from Halligan's defective appointment, including this indictment, must be set aside. There is no alternative course, and so I have to dismiss the case. The government says that's ridiculous. It's been validated, this entire process, by the U.S. Attorney General, and they say she was still a valid attorney. Even if she wasn't a valid U.S. attorney, she still brought this indictment appropriately, and they rely on the 1031 order. But the judge is going to say, sorry, you can't do that. This is not a mere paperwork error, okay? When she got originally appointed, Pam Bondi put her in here Section 546. And by the way, it's easy to come and blame Pam on that, I think, to say, well, you would have been smarter if you wouldn't have done this because this gave them an opening to say that her successive appointment was invalid and dismiss all of the indictments. But what they were trying to do is make her the U.S. attorney. And this is going to be an important battle to wage anyways, not just as it relates to these prosecutions and Lindsay Halligan, but we want to make sure that the executive branch can actually appoint their U.S. attorneys. So they use this statute. Maybe it's the weaker of the statutes because it enabled this attack, which was to say 120 days is time limited. But you also want the DOJ to push that envelope to say, no, we can appoint our attorneys. We're the executive branch. We get to appoint our people. We don't divest ourselves of that power because some court somewhere say so. So we're going to have this battle. You know, it kind of sucks that we're having it with Comey. We got to have Comey and Letitia dismissed, but we're going to have this battle one way or the other. So it's hard to really blame them for using this statute. They then created a backstop when they're like, oh crap, they're going to dismiss on this basis. They then came out and tried to use the 1031 order with different statutes, 515 predominantly. She says, well, sorry, you're not a special attorney. But my point in going through this in so much detail is that this status, somebody else I think could be appointed as a special attorney now that the case has been dismissed, which creates the safe harbor window of the 6-month statute of limitations kind of safe harbor provision, would allow a new special attorney if we're not appealing it, or maybe you prosecute these things simultaneously, but you actually would appoint a new special attorney. But regardless of what the attorney general intended or could have done, the fact remains she wasn't authorized to even conduct these when she got the indictment, and now it has to be dismissed. Now, the government also says that even if Halligan lacked the authority, we're entitled to de facto validity. But this doctrine applies only to some non-constitutional appointment challenges. This is a constitutional appointed position, and so that analysis doesn't apply. But third, the government also says, well, the grand jury came to their own independent decision, and so it's harmless error. But they say harmless error doesn't apply here anyways, because she didn't even have the power to go in and present the evidence to the grand jury at all. Now, the government finally argues that even if Comey's indictment is flawed, dismissal is inappropriate because the AG ratified this. But all of it happened after the statute of limitations. I've already concluded, writes the judge, that Halligan's original appointment was invalid, and you can't retroactively fix it, saying the AG could not have authorized Halligan, anyone who was not an attorney for the government at the time to present the indictment, right? There's essentially saying the very moment that she was appointed, that was illegal because only the courts can come in and actually appoint somebody to that seat. Now, the implications are extraordinary. It would mean the government could send any private citizen off the street, attorney or not, into the grand jury room as long as the AG approves it after the fact, and that's not the law. So the government is not satisfying this ratification. Pam Bondi can't revert back. And here's an interesting footnote. Generally, the return of an indictment tolls the statute of limitations on the charges contained in the indictment. In other words, the clock stops. You've got, in this case, a 5-year window to prosecute James Comey. Charges are filed. Clock stops on the window. Here, though, this indictment was invalid, so the clock did not stop. A valid indictment insulates the statute of limitations, but if the indictment is void, there's no peg on which to hang this tolling result. Okay, so in other words, the statute of limitations has also expired. Saying here, now on October 31, Comey's indictment was still pending, and so the clock expired already. Thus, the AG could not have invoked 3288 at the time the ratification was made. And what is 3288? Our friend Will Chamberlain pulled this up for us, and he said, this is an important note here, okay? When you have a dismissal of an indictment, he says, because the original indictment was timely filed against Comey, DOJ has a 6-month period to re-indict, even though the statute of limitations would have run by now had Comey never been indicted. And here's the statute. It says 3288. Whenever an indictment charging a felony is dismissed after the statute of limitations has expired, a new indictment may be returned in the appropriate jurisdiction within 6 calendar months of the date of the dismissal of the indictment and more. If no regular grand jury is in session, then you've got a couple of exceptions to that, but this section does not permit the filing of a new indictment if the reason for missing the statute of limitations, like if you miss the window, you're like, oh, I just forgot to file it. You can't refile it if you failed to meet the statutes the first time. So you might call this like a safe harbor provision, to use a contract term, or an opportunity for prosecutors to cure a bad indictment and refile the charges. And so let's put a pin in that, right? The judge is saying, hang on, you can't use that in certain circumstances. And here's what the judge said. Okay, 3288, the Attorney General could not have invoked this at the time the ratification was made. In other words, Pam Bondi on October 31st couldn't have approved Halligan's decisions because it was an active indictment. So she can't reappoint Halligan because it's an open case. But guess what is now the situation? The case is dismissed. So now we can use 3288 because the case was still open back then. It's invalid. The case is now dismissed. So now we can use that, which means you could say that they could use Section 515 to appoint a special attorney, probably not appoint Halligan, but you'd appoint somebody else. And then they could use 3288 to invoke the 6-month window and bring a new indictment, all while simultaneously appealing the case. So there's 2 options there that I think are pretty good. It says, having found that Halligan's appointment violated 546, which is the 120-day consecutive law, and that the dismissal is warranted, we now should ask whether it's with prejudice or without prejudice. And as we know, it has been without prejudice. It says, I believe the appointments clause jurisprudence begs the question, and I will invalidate these, and I'll just dismiss the indictment without prejudice, returning Comey to the status he occupied before being indicted. And so therefore, judge finding that U.S. attorney violated Section 546 because she was appointed 120 after 120. And I think the courts will probably reverse that. It seems ridiculous, just as a matter of public policy, without getting into all the case law, that the courts, because of an empty seat, get to usurp executive power. I think may in there is for a reason. It's may. It's not yours. You can, help yourself to the refrigerator if you want and, open the door, but it's not yours. It's the executive branch. And so for this judge to take it away from the executive, I don't think the Supreme Court's going to sit by that. All actions flowing are set aside, and any AG attempts to ratify Halligan are also set aside. Motion to dismiss granted, indictment dismissed without prejudice. And she says, this is her main ruling, which I think is probably going to get reversed. The power to appoint an interim attorney during the current vacancy lies with the district court until we get a Senate confirmed attorney. Okay, so in other words, in this district, until we get a Fourth Circuit reversal or a Supreme Court stay or a reversal or any of these, limitations on this Clinton judge, the court will appoint the next U.S. attorney. So the idea is nobody else is going to be filling that seat. A special attorney, I would argue, would be outside of a U.S. attorney. So if she uses Section 515 to go and appoint a special attorney, Pam Bondi's already tried to do this. She already tried to do that with Lindsay. So just go do that again for somebody else who is going to investigate and prosecute these cases. Also appeal this one because we want Lindsay Halligan in the U.S. attorney's seat, and we want the executive branch to have the power of appointments, just like the Constitution says. So this judge, I think, is just way off base, and I think that she'll probably get reversed on both cases, but this is also the Letitia case. And again, saying nobody else can come in. So they can't put in another interim attorney. It's got to be Senate confirmed, presidential appointed, Senate confirmed before they'll accept them. And the Democrats are not going to agree to appoint anybody who wants Comey prosecuted. If Comey gets tabled, then we'll push through the Senate a new U.S. attorney, but you can see how politically this is going to be a difficult thing. So two options: one, appoint a special attorney under Section 515; two, appeal this, get Lindsey Halligan reinstated, and have the courts find that successive appointments are perfectly valid under Article 2 powers. So difficult decisions that came down, but ultimately I think that they're just as bad as anything we've seen from these other judges who've all been reversed. So it is going to continue to be a battle, and I think that the Comey folks are celebrating a little bit too early. They're popping that champagne bottle, which they shouldn't be doing quite yet. Chad Mizell, no longer with the DOJ, but he was with the DOJ. He said wrong just until very recently. Wrong for many reasons, he says, including that dismissal of these indictments is the wrong remedy. Okay, even if you think Lindsey Halligan was illegally appointed or something, you still had a valid indictment from an attorney who was working for the U.S. government, even if the title was wrong. And so the idea would be they're going to dismiss a criminal charge, 2 felony criminal charges, in this case multiple, against Letitia and Comey, that a grand jury duly approved just because of some technicality. We'll see. Both indictments were ratified by senior DOJ leadership, including the AG. This may delay justice, says Chad, but it won't stop it. An appeal is coming. Comey and James are not off the hook. Caitlin Collins said Letitia was very happy about this. After her face stopped spasming out, she said, "I'm heartened by today's victory, Letitia, and grateful for the prayers and support I've received. I remain fearless in the face of these baseless charges as I continue fighting for New Yorkers every single day." But Harmeet came out and said, without prejudice means we can file this next time and come back with a second set of charges and a new indictment with a valid U.S. attorney.